What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And a Happy New Year to everybody out there. It's going to be a big year, 2024, for combat sports law, especially what we're going to be talking about today, which is the UFC lawsuit. Over the course of the holidays in December, we've had a little bit of movement in the UFC lawsuit, and I talked about it previously in the motion to exclude Hal Singer. The Zuffa lawyers have also moved to exclude 3 of the 4 plaintiffs' experts, including Singer, also Andrew Zimbalist, and Guy Davis. Those 3 experts pertaining to Singer's expert report related to the damages the bout class suffered or allegedly suffered through UFC anti-competitive conduct. Zimbalist and Davis's expert reports, which were related to the fact that the UFC could have paid their fighters more during the time period of the class action lawsuit, as well as the fact that the damages, what the anticipated damages of the fighters may be. So Zuffa has filed a motion to exclude. As we discussed earlier in the Hal Singer legal submission, they also did not bring up that the motion to exclude was already discussed when Judge Boulware issued his written opinion on certifying the bout class in the UFC antitrust lawsuit. So there is that issue. Now, the plaintiffs have filed a motion to strike. Motion to strike basically saying that the motion brought by Zuffa should be not heard or issued a judgment by the court because of legal issue of the fact that it came improperly before the court. So striking a motion means like don't hear it. That's what the plaintiffs in the Zuffa lawsuit want to do. Now, in their motion to strike, the lead plaintiffs obviously contend that Judge Boulware has already issued his opinion on the expert reports of Singer, Zimbalist, and Davis. And you could see that in the order he indicated that the methodologies, especially of Dr. Singer's, was allowable in court and considered when they filed the motion for class certification, and he considered it when he issued the order granting class certification for the bout class of fighters. Zuffa, in their motion to exclude, which came out at the beginning of December, decided that the decision by Judge Boulware was not adjudicated regarding whether or not the anticipated testimony would be allowed in court. They believe that the fact that Judge Boulware dismissed the motions to exclude for class certification without prejudice, that they could still bring up further arguments. Now, with and without prejudice are very technical legal issues in courts. With prejudice means that the issue has been solved and there's no way back to argue it before that particular court. Without prejudice means that there's a possibility that you could bring it back to that particular court. So now Zuffa is hinging on that particular notion that the issues have not been quote unquote adjudicated. There is not a finality before Judge Boulware's court. That's what they're basically saying, and that's what they're hinging on. Obviously, the motion to strike claims that that's a farce, that is not that is not correct. It's improper, and it's only the reason why Zuffa is doing this at this particular point is to ensure that they prolong this lawsuit even further and extend the April trial date to longer out in the future. Now, in Zuffa's opposition to the motion to strike, Zuffa claims that it was proper in bringing the motions to exclude simply because of the adjudication issue. Also, the fact that there are outstanding issues that they believe the court should address. Two things of note. One is, of course, the attack on Hal Singer in a recent ruling with Epic Games and Google. Hal Singer's expert report was disregarded, and they had also indicated three other cases in which Singer's expert report was disregarded by other courts, therefore bringing circumstantial evidence to this particular expert report, inferring that there could be something wrong with that. And to buttress their argument, Zuffa has brought in a new expert, a Dr. Leonard, to examine Dr. Singer's expert report and provide a declaration which was attached to their motion to exclude Dr. Singer. Now, usually, and in fact brought up by Zuffa's motions to strike, plaintiff's motions to strike, you cannot bring up new experts. You can't bring up new experts after the court deadlines. The court sets deadlines where you can provide experts, and they give you an allotment of time to challenge those experts, meaning they can disregard those expert testimonies, expert reports, what declarations, whatnot. There is ample time, and that's within the court's discretion. And but of course, the schedules allow for some sort of organization to the court, so you don't get last-minute filings and things of this nature like we're experiencing now. Zuffa believes that Dr. Leonard's testimony sheds some light on the particular issues at hand, and in fact has even welcomed the deposition of this newfound expert, and it states that there is ample time before trial to get his information done and take his deposition and focus on what his testimony will be. Now, obviously, plaintiffs don't like that. Zuffa contends that plaintiffs are overreacting, and so on and so forth. The other thing that Zuffa had argued is that there has been an amendment to the federal rules of evidence which suggests that it is the court's ultimate responsibility, the judge in this case, to determine whether expert information should come before a jury. What does that mean? Well, that means on these Evidence Rule 702, which is the one you could look it up, Daubert claims. Daubert is the case that is the overarching case, the seminal case, which talks about whether or not you should let expert testimony in, and it's a very, I guess you could say, vague, subjective benchmark as to what comes into a court. Mainly the information that can be included in expert testimony is based on industry standards. And if we go back to this case in which Judge Boulware had allowed Dr. Singer's expert testimony in, he believes that this is an industry standard, Dr. Singer's regression theory. So what happens next? Well, there's a lot of issues coming here. So what happens next? Well, we still have a reply brief to wait on from Zuffa regarding its in support of its motion to strike. So that will be important. But also, we see now that Zuffa, whether or not they intend to do this, and let's be honest, they probably intend to do this, is looking to extend the time by finding new experts, finding new amendments that happened post 2017 to bring to the courts bring it to the court's attention. Now, the fact of the matter is that the timeline here is certain time from is anything pre 2017 is included in this case. So post 2017 would fall under the Johnson case, and here Zuffa is talking about issues that happen currently, which relates to the recent Google case, the amendments to the Federal Rules of Evidence, and the issue is whether or not the court should take those into consideration when the case revolves around a set time pre 2017. So should the rules that have been implemented post 2017 be considered for a case that happened pre 2017? That's for Judge Boulware to decide, essentially. Now, if he allows it, and I think that he may allow some, maybe not all, maybe not Dr. Leonard's testimony, but some of this information in, does that open the floodgates? Does that open the gates to include information post 2017? The fact of the matter is, Zuffa had wanted to include information post 2017. That was in their summary judgment motion. Notably, the fact that other promotions have been successful and utilized their own contracts, similar contracts post 2017. Now, that's something that we'll continue to follow, and we will probably be getting more of this information as it steamrolls ahead to April. Once again, this is Jason Cruz for MMA Payout, the legal submission. Have a good day.